Good morning, everybody. I hope you are all well. I would like to welcome Mrs. Carol Catt. She is head of copyright and short courses, and she started her career in 2003 at the university. So yes, she is head of short courses, trademarks, and copyright. And we all know her by now, all staff know her by now, and she always comes back so fast with a wonderful answer, and we know we are on the right track. She expanded the role of the SO Copyright Office by developing institutional copyright guidelines, managing and administering the protection of Stellenbosch's own content created by its staff and students, establishing and implementing reporting processes against the background of the DALRU SU blanket license agreement and ensuring compliance thereof. Big words. Thank you and a warm welcome, Carol, to you. Over to you now. Thank you.
Good morning, everyone. And thank you very much for this opportunity, and thank you for joining me this morning for this presentation. And thank you, Marlene and Kirshner, for this opportunity to be able to present another copyright session at your Library Research Week. I'm going to share my screen with you now. Please just advise me if you can or cannot see it at that stage. Is everybody able to see?
Yes, I can see it.
Thank you. Right, as Marlene indicated, my name is Carol Catt and I head up the Copyright, Trademark and Short Courses Division at Stellenbosch University. This division is housed within InOffice, which is our intellectual property office, as well as our technology transfer office, as well as the office that is responsible for managing the spin-out company portfolio of the institution as well. So as you can see, we are quite a diverse office. We have all these different profiles that we fulfill. So we don't just deal with copyright, we deal with trademarks, we deal with patents, we deal with plant breeders' rights, industrial design law, inventions. So it's quite an interesting office where we all have different portfolios which we fulfill. Unfortunately, copyright is not the most riveting topic that you're going to hear or address in the next couple of days with your Library Research Week, but it is a very important topic. So I'm going to give you a little bit of background regarding copyright before I proceed with what you may or may not do. It becomes quite a grey area when you may or may not use somebody else's content. But as researchers and as postgraduate students, you're not just going to be using somebody else's content, you're going to be creating content as well. So you're in this unique position where you're going to be using somebody's content, but you're also going to be making your own content. So it's quite important as you move through your academic career, a copyright becomes an aspect that you do start considering. So just to give you a bit of background, copyright is an intellectual property right. It has an economic and a moral function. So if you are potentially infringing somebody's copyright or somebody's infringing your copyright, it not just has the moral function of the infringement, but as well as the economic function. Especially if you're the author or creator, it affects your royalties. If you're publishing works or a book and somebody is just illegally or without your permission using it. This copyright in this work that you are creating or that somebody else creates grants the person a number of exclusive rights. So you are in the position to allow someone to do something with your work or to prevent them from doing something with your work. Those decisions are right up to you. Copyright also exists on all literary, musical, dramatic and artistic works of authorship. So on paintings, on anthologies, court cases, paintings, writings, books, journals, anything that is in a tangible form, copyright will subsist in it. Now, unfortunately, in South Africa, we are sitting with a heavily outdated Copyright Act, Act 98 of 1978. I think the last amendment of this act was in 2001. So as you can see, very much out of date, does definitely not make provision for technological advancements. And also, as you will note, it is mainly based on printed distribution and printed matter. So now you have a problem because we have advanced technologically, as you can imagine, since 1978. So our government in 2015 set about drafting a new copyright amendment bill, which has a lot of new limitations, but also a much broader academic exemption. However, this piece of legislation was firstly badly drafted. Secondly, it received a lot of criticism, not just from academic institutions and publishing associations and authors, but as well from a whole group of legal, let's say legal eagles that are experienced in intellectual property law. As a result of this bill was finally made available for public comment with parliamentary hearings mid-2017. Stellenbosch University did present on 2 occasions at the parliamentary public hearings. However, they proceeded to go ahead with this badly drafted legislation into Parliament, and it passed through the National Assembly and National Council mid-2018-2019. However, June 2020, our president referred it back to Parliament to go and review again because of all the criticism that this bill actually incurred. And subsequently, last week, in May 2021, our president has now referred it back to the Portfolio Committee of the Department of Trade and Industry for further amendments. So right now we're sitting with 6 years later, no updated copyright amendment bill, an outdated piece of legislation that we now have to apply in our environments. So why is copyright important to you while you are researching or while you are writing? So let's have a look at it. You've got infringement risk, as I mentioned previously. You're using someone else's work. However, you also want to protect your own work because somebody else could infringe your work. So your copyright subsists automatically on any work that you create, as long as your work is original and if the material in which it is in a tangible format. In other words, there is no copyright in an idea. As long as the idea is formalized in your head, it's not going to enjoy protection. You have to have noted it down somewhere. We also advise you when you're noting down something, put the date on it. Put 2021 or July 2020, because that means that's when you created the work, and then your copyright subsists from that point forward. Also important factor, there's no expensive registration formalities. Patents, trademarks become an expensive exercise to register and to keep renewing the registrations. Your copyright subsists automatically for protection. If you're students at Stellenbosch University, it's also important to you because when you are registering for your degree or courses that you are studying, you are in the process, if you read the fine print, assigning your copyright in all the works that you create during the course and scope of your studies at the institution. And this includes all your research that you've conducted, your papers, your assignments, your dissertations, and your thesis. So that's an important factor to remember because when you come to publish, you are not in a position just to assign anything where the rights belong to Stellenbosch University. Also, it's going to be important to you because as you go down the line of your research and obtaining your qualifications, you're going to start publishing. And publishers want ownership of your copyright. They also want your electronic rights. So we caution you against granting exclusive rights to a publisher. This will inhibit your research going forward. So we always advise you to find some compatible solution with the publisher so it results in negotiations. So these are important factors to remember while you are researching and writing for your degrees. Let's look at ownership of copyright. Who owns what? So basically, the owner of any copyrighted work is actually the person who created the work. But as usual, there are exceptions. So let's look at employment. As a staff member at Stellenbosch University, while you are busy signing your agreement to start working at the university, you assign anything you create in the course and scope of your employment. So there is an example of an exception. I've created the work, but I don't own it. Commissioning. You get commissioned to paint a picture or you pay an artist to paint the picture. He owns the work, he created the work, but there is assignment of the ownership to the person who commissioned it. So that is called ownership by commissioning. The other factor you've got to look at is state-controlled papers. A lot of these white, yellow, green papers of the government are written by institutions, but the instruction to write them came from the state. So the state actually owns that work that you then create. Typical example is now currently during the pandemic and all the research that is taking place. And I'm not sure if you're aware, but there is now a drive to have the patent behind the vaccinations, not to claim intellectual property on it, so that it can be globally utilized by everyone, so that we all have the benefit thereof. So that is almost a typical example of a state controlled, where you are creating something, but the state actually owns it. I've mentioned previously, Stellenbosch University is the sole owner of any work you create in the course and scope of your employment or in the course and scope of your studies at the institution. As a student, you have to be very cautious because outside organizations provide you with a bursary. However, these bursaries do not cover the full cost of your studying or research. You are still depending on publicly funded research. So according to the Intellectual Property Act of South Africa, we may not allow students to grant intellectual property rights of work they've created directly to any outside organization or to people providing their bursaries. This has to be negotiated as well with these organizations. Another important fact regarding ownership, because you're not just going to be writing, you could be possibly co-authoring something. So in copyright, your copyright in your work lasts for the duration of the life of the author, plus 50 years after the death of the author. Thereafter, the work should fall in public domain, but in certain instances, let's say look at Walt Disney's works, obviously it's not going to fall into public domain. That gets bequeathed in an estate to your trustees, and there is always someone managing these very important rights. Please note, when you're co-authoring, the duration of the copyright in a specific work lasts for the duration of the life of the longest surviving author, and then plus 50 years after that author's death. Also note, in South Africa it's 50 years, but in the US and in the UK and in other countries, that duration can differ. US and UK is 70 years after the death of the author. So now you want to use third-party content. You are now in the process of researching. You need to write either an article or you need to write a thesis. You need to produce a work, but you're using third-party content. So what may you and may you not do? So let's have a look. Your basic copywriter principles apply throughout. I normally advise that if you are busy using a piece of work and something in your mind tells you, should I actually acknowledge this? Do I need permission for this? The fact that you're starting to question it indicates that perhaps you should research a little bit further, but possibly permission is required. Your basic guideline would be, when you would need to request permission, is if you reproduce, publish, or communicate any articles or theses in a material form. So in other words, I'm talking about what you are creating. So if you use a journal article or you use something out of a third-party source, just think long-term. You're not just going to be using it for personal use. You are going to be communicating this article in a print format or electronic format. So you're going to be publishing, you're going to be distributing. So if there's third-party content, err on the side of caution and request permission. Be careful if you use or you summarize a whole or complete text. If you take a whole journal article of someone else and you summarize it, you have created a new work of somebody else's work, and you're not allowed to do that without their permission to do so. Your next point is, and this is quite a sticky one to deal with, is using a substantial part of copyrighted material. Because your substantial part on copyrighted material doesn't just work on quantitative, it works on qualitative as well. So if you reckon I'm using a 20-page article, of which I'm actually only going to use a page or 2 pages, in your mind, that quantity is actually a very reasonable amount. However, the quality of that piece of work, in other words, the crux of it could be in those 2 pages, then it would be considered substantial. So it's the essence of the work you have to look at, as well as the quantity of the work that you are using. If you're unsure, request permission. The next point, and this is always a bone of contention, using photographs, diagrams, maps, graphs, any images in your work, you need permission. There's this understanding that if I take this table and I use it and I just acknowledge it or indicate I've changed it, I'm allowed to do so without permission. Unfortunately, any visual element, photographs, diagrams, maps, graphs, represent a whole work. You're not going to put half the photograph or part of the diagram or part of the map out there. You're going to put the whole work out there. And it's an artistic work and it enjoys copyright protection. Request permission. Now it sounds to you as everything that you're doing or that you've currently done so far, permission is required for everything. There are certain instances where you don't request permission and where you're able to, I'd almost say, customize the content to a certain extent without permission. So you paraphrase it, you rewrite it but also, again, insubstantial comes into play. So you paraphrase a very small part of the original work in your own words. And as always, that you have to reference the original source, because it's not your idea, it's somebody else's idea. When you use an insubstantial part, permission is not required, but as discussed in the previous slide, be careful because you've got to do the quantitative and the qualitative measure thereof. You are able to quote a small part of copyright material. Now, typical copyright legislation never defines words like substantial, insubstantial, small, or reasonable or unreasonable. It never is clearly defined. It's always a very gray area. But if you're quoting a small part, obviously 3 pages out of a chapter or an article is not a small part, but a page could be considered a small part. Remember to use quotations marks and to use correct referencing of your source and author. You are also able to cite a source in your text, but here again, be careful how you cite the source. Even if your research is not in agreement with the source that you are citing, you are not in a position to offend the previous researcher's research. You can indicate, according to Mr. Jones, and give the whole article where it appeared, this was the results of his research. However, my research indicates differently. Be careful that you don't indicate that you totally disagree and that the research is nonsensical and that it can't be used. You cannot put him in a negative light. You can disagree with him, but you can't put him in a negative light. You don't need permission if you're using a random piece of data. Now, in the scientific and mathematical environments, your mathematical and scientific formulas do not really enjoy protection. They're considered public domain. E equals mc squared. So if you're using E equals mc squared, you don't need to request permission. However, should you then take that formula, and you combine it in your own formulation, that's a whole complete new piece of research, it may then enjoy copyright protection. So just be cautious and just make sure you know what is actually in public domain and what is not. And then we come to the wonderful world of open access. Now, open access, there are a number of open access websites where you can freely and openly use information that is available. However, check your licensing provisions, especially with regards to CC, which is Creative Commons licensing. There's 6 licenses in total. Your first one obviously being the least restrictive, so you can do almost anything with the content that you're accessing. You may amend, you may distribute. You don't even have to acknowledge in some instances, and it goes right up to the 6th license, which is your most restrictive. And there it will indicate to you it's for non-commercial use only. So be careful. If you're using it and it's non-commercial, you're going to be publishing in the future, earning royalties. It's got a commercial spin to it. It's also your most restrictive license doesn't allow amendments or adaptations without permission. So before you access content and use it and start modifying it, first check what you are and are not allowed to do. Now, I'm pretty sure that somewhere in your journey in academia, you've heard of the term fair dealing. And now, does this actually apply to your research? Bearing in mind that American legislation refers to fair use, South Africa's old outdated legislation refers to fair dealing. The new amendment bill does make provision with a couple of clauses for fair use, but obviously this can't be implemented. Also, fair use is used widely in the US in academic environments. However, we are still stuck with our outdated legislation. So unfortunately, fair dealing has got a few provisions that you're going to have to adhere to. In Section 12.1 of the Copyright Act, it clearly states that it's simply for purposes of research or private study, or for personal or private use. You may make a single copy, but here again we go into the grey part of the legislation where it says of a reasonable portion of work consistent with fair dealing. So they consider a single copy of a reasonable portion, but don't define reasonable. So it's a little bit uncertain. It's also only for personal or private use. So if you're going to be publishing your thesis in the future or your journal article in the future, you can't rely on a fair dealing provision in the Act to provide you with protection. Firstly, because a large portion of a work that you're going to copy or be using is not reasonable and they don't consider it compatible with fair dealing. Secondly, since you're going to be distributing and communicating your writing, be it in a journal article or in a thesis or in a paper, it's going to go out maybe to the general public. So this does not allow under this clause it does not qualify for personal private use. And then also, as I've mentioned, this is not clearly defined in the Act. So unfortunately, you're not going to be able to rely on this provision should you be infringing. Now, we often get asked, what is the difference between plagiarism and copyright? How do these two play out against one another? And interestingly enough, there's a perception that if I've plagiarized, I haven't infringed. And if I've infringed, I haven't plagiarized. And that is not correct. There's a lovely diagram on Wikipedia, which I'll share with you now, and which we are free to use and distribute with acknowledgement. You will see that there is a band in the middle. As the two circles overlap, there is most certainly a band in the middle where there is copyright infringement and plagiarism. So let's look at it. So what is plagiarism? Plagiarism is when you don't say where you took it from. So in other words, you take a work, you copy it exactly, and you pass it off as your own work. No acknowledgement, no attribution. So that's plagiarism. Copyright infringement is when you take it without permission. So now if you look at plagiarism, you're passing it off as your own work, but you've actually taken it without permission as well. So there's a high possibility you are going to have both. If you're plagiarizing, there's a strong possibility you're going to have taking without permission and passing it off as your own work. Now we've got to look at this further. So plagiarism, let's look at that. It's a violation of moral rights and of academic standards. It's almost a more emotional infringement than what copyright infringement is. It also involves verbal or written copying of the original. So you will basically repeat verbatim what somebody else said, a quote or whatever, and you pass that off as I thought this up or I said this. Writing it out means you're basically creating your own work by writing this written, by creating this written work. Plagiarism is also present when you don't attribute the authorship of the copied material. So let's do it verbatim, but let's say, according to the American humorist Art Buchwald, he quoted the following: you've acknowledged him. So then there's no plagiarism because you are indicating I did not create this. So your main thing on plagiarism is the moral infringement of the author and the reputation of the author that you are infringing. And it's not a very good practice according to academic standards, obviously. So let's look at infringement in comparison. Copyright infringement is most definitely a legal violation. It also doesn't just mean that you're writing somebody else's work and giving it off away as your own without requesting permission, but there's physical reproduction also involved. So it's a PDF that you're going to download off the internet, or it's a book that you're going to scan in and PDF it and reproduce it. That's a physical reproduction of the original. So whereas the other one was just verbal or written, this is a physical reproduction. Secondly, not only do you not attribute, but you fail to obtain permission to make these copies. And then an important factor, in copyright, in many instances, you're going to be asked to pay a fee for using content. So now we have the situation where you fail to obtain permission, but you're also not paying the copyright fee that is required to use this material. So now we're sitting with an infringement, not just of the author's moral right, but now we are affecting his royalties and his potential income. So we have an economic right now that we are also affecting. So you can see now the differences, and you can also see that it is possible to have plagiarism and copyright infringement in the same instance of work. So now I've given you all the do's and the don'ts, but now you need to get this permission. You've suddenly realized, oops, I need permission in this instance. How are you going to go about requesting this permission? My only advice I can give you in this instance is to start in time. It can become a lengthy process, and it's also quite, I'd almost say, disheartening when you start out and you see I've got 15, 16, perhaps in some instances 25, 28 items that I need to request permission for. It is disheartening because you're not always going to get a response. So my advice is start in advance. Don't start 2 or 3 weeks before you're going to hand in your work and then discover I now need to request permission, because it's not going to happen overnight, and that is a given fact. The reason for this simply being, if you are requesting from publishers, and even in some instances from authors, they don't make masses of money out of granting copyright permission and charging a copyright fee. Their core business is royalties. They make royalties for their authors. So they are going to, obviously, if your email floats into their inbox, they're going to first and foremost give, I'd almost say, a preference to the authors and the author's rights and the royalties than before they're going to grant you permission. Because in most instances, when they come to you and they grant you permission, we're going to ask them to give it to us for free. So they're not going to be generating income off it. So now how are you going to obtain permission from the rights holders for any third-party content you're wanting to use? Let's have a look. Let's start at the beginning. Check the terms of use of material. May or may I not use this material? That's the bottom line. In very many cases, if you go onto some of your government websites, even some of your non-profit organizations' websites, they will tell you you are free to use this content for non-commercial academic purposes. That's great. We are in an academic environment, this is non-commercial, but just let the little flag go up, because if you're going to be publishing and earning royalties, there's going to be commercial distribution later. So first check what you may or may not do with the material, and if permission is required or not required. Now you've determined that. Now we look at open source. If it tells me it's in public domain, let me go and see what the requirements are if this work falls in public domain. Must I just acknowledge the author? Do I need no acknowledgement? May I share this widely? May I amend it? And again, check your Creative Commons licenses if you're using work that's been uploaded under Creative Commons licensing. Now that you've determined those two factors, you've next got to look at ownership of material. It's not always clear-cut that the publisher owns the journal or article or the book chapter. In some cases, authors assign their rights to the publisher, then the publisher owns it. But there are cases where the author holds the rights to his own work. So there's no point going to the publisher to request permission. They're going to refer you to the author. In the same instance, if you go to websites, there may be an article that was placed by a journalist, especially in newspaper articles, and they don't necessarily assign those rights to the website owner. So you can contact the website owner or come back and say, I don't own the rights to the content. So important to determine where the rights for that article or that content lies that you are wishing to use. Also remember, do not request permission verbally, because that's not going to hold up in a court of law. Request permission in writing from the original copyright owner, be it the publisher, be it the author, be it the website owner. Get that permission in writing and store that permission in case you need it in the future. When you are applying for permission, it can become a lengthy process, and it can administratively, it can actually weigh you down, because it will be backwards and forwards. So right from the beginning, give as much information as you can about why you want to use this content, where you're going to use the content. So you've got to indicate non-commercial academic use, it's going on my thesis, and then also indicate it's going to be print or electronic, it's going to go onto Sun Scholar or onto an academic repository. Indicate I'm going to be publishing later commercially. Indicate all these factors up front, because then it just makes that backwards and forwards with email communication. It cuts that down somewhat for you. You must continue until you receive a reply. Do not just assume after 6 weeks that no reply means I may use it. That is not the case. Keep following up until you've built up a sufficient paper trail where you believe, I have tried and pursued every avenue and I can't get permission. So those are I would almost say the points that you should need to touch base when you're trying to request permission. Now you're going to hit a couple of stumbling blocks. Firstly, you may not receive any response to your attempts. So that is, in, I won't say 90% of the cases, but there's a large percentage of the cases where you do not receive a response. Your next factor is the publisher especially may ask you for payment of a copyright fee. Now, if you are using 12, 14 articles or information or images in your writing, it could become a costly exercise, especially if you're looking at dollars and pounds and an unfavorable exchange rate. So now you're sitting in a little bit of a crossroads. What are you going to do? So you've got to firstly decide, do I actually need this content? Is there something that somewhere else that is similar that I could perhaps use, that I can perhaps replace it with, and where I potentially would get permission and not be charged a fee? It's not always possible to do that. In some instances, we do have students where they are writing their thesis, where they decide it is they do need the information, and out of their funding, they are able to provide or cover that copyright fee. We also advise you to be very careful when you're using questionnaires or you're using studies of certain medical institutions, especially. They charge you an astronomical fee to make use of that questionnaire that you want to include in your writing. So be cautious of these pitfalls. You can also look, if it's a small enough piece of material, to paraphrase it. In other words, to rewrite it in your own words with crediting of the source and the author. Then you won't need to request permission. You can also, as we discussed in the previous slide, reduce the extent of the material that you want to use to become an insubstantial part. Also, again, crediting the original source and author. But as I told you, this is quite a difficult test to do, which you must determine, is this insubstantial or a substantial part? So there are ways and means that you can go about this and that you can facilitate this. But now you've been given permission, all your attempts have been successful. Now you need the next step. What may you not do with the material for which you received permission? So let's have a look. We just generally advise you to credit the original source. In some instances, the author may indicate you don't need to credit him. Just credit the original source, because somebody else using that material would actually like to know where it came from. So credit the original source. Also, state if you've altered or modified the material from its original format. In this instance, only if you have been given permission to alter or modify the material. Do not alter or modify material where you don't have permission to do so. And then also remember, you can only use the material in the manner for which permission was granted. So if you requested permission for printed format and you now go and put it on an electronic platform, permission wasn't granted for that third-party content to be made available via that platform. So be careful. Upfront, request digital and electronic. Just cover all the aspects so that you don't end up sitting with something that you can't utilize. Most importantly, you may never alter or distort the original material in any way which is going to damage the author's moral rights. You will not be sitting with a copyright infringement suit because you received permission to use it, but you will be sitting with a defamation of character suit. So do not distort it in any negative light. So now you have now gone through all the obstacles, you have cleared all the hurdles, you're now at the point where you're submitting your work for publication. Let's say it's your thesis and you've suddenly been submitted, your degree has been conferred and you're now getting seen and noticed and you're now needing to publish. So what happens now? Again, we go back to my first slides originally. Students and staff assigned to issue all the rights in all the works they create during the course and scope of their studies and during the course and scope of their employment. Students, your assignment is on registration. Staff, your assignment is as a condition of employment when you sign your employment contract. That's one point. Next point. Our SU calendar, our yearbook part 1 general, has got clear guidelines regarding provisions for your format and how you have to create, especially with thesis writing, submission, duplication, and publication. Please also note, you may not publish assignments, theses, dissertations in any form other than an article in an accredited academic journal without prior written approval of the dean of the relevant faculty to which you belong. It actually goes even further that you actually need the permission of your supervisor if it's in a postgraduate degree, as well as of the HOD and the dean to go ahead with this publication. An important factor is that Stellenbosch University, even though we own the intellectual property, we are not going to claim income that you could potentially generate from artistic, literary, musical, or dramatic works, even if this work is pursuant to your studies or to your employment. We also, though, do not contribute to the cost of your publishing. So when we do get to the point where you have to publish and you need to negotiate assignment of your rights, our office, as the Intellectual Property Office, is always available to advise and to provide you with assistance regarding any intended publications you may have. If it is legally capable there to know, you must just remember that because this all forms part of publicly funded research, and according to certain provisions of the Intellectual Property Act, we're not always able to give you copyright in certain works. But we then grant you a usage right. If we're not able to assign copyright to you, we give you a usage right for a specific publication. You are perfectly entitled to the income out of all these publications, but we are not going to pay for all the publications either. So if you come after having your degree conferred and you're now negotiating with a publisher to write a book, you're welcome to approach us. We will assist you and advise you regarding the clauses that you need to make sure in your agreement. You will request the permission from your supervisor, your HOD, and your dean. INOFIS will grant you permission or usage rights to use the content, and you are good to publish. But all the costs associated with that publication are for your own account. Now, just a word of advice. We advise you to choose a specialized academic publisher with a high quality end product. Why? Because there are a high number of predatory publishers out there. These publishers spend their life surfing the internet, looking for works on our institutional repositories, on open access platforms. They then get that work. You feel incredibly flattered because this publisher has approached you to publish. However, please note, a predatory publisher will first and foremost usurp your IP. So you're going to lose your intellectual property, you're going to assign it to him. Then you think you're being published. We've had a couple in the, not during the pandemic, but prior to the pandemic, where lecturers and postgraduate students were presenting at international conferences overseas, and their papers at these conferences that were presenting were being published. The email or the website addresses of the predatory publisher are so similar to that association or that organization that's arranging the conference. You don't even pick it up unless you actually go letter for letter, commas, underscore, word for word. Then you discover the email address is not the same or the website's not the same, but you've already submitted your paper. And you end up with this predatory publisher holding onto your paper, holding onto your copyright, which you've assigned to him in total. Now you want it back because you want to continue with your research. Now he holds you to ransom and he charges you money to get your copyright back. We have in the last, I'll say, a year during the pandemic negotiated with a couple of these predatory publishers to get very important research back that had actually ended up in their domain. However, it is a costly exercise and it's not a pleasant exercise, and it incurs legal expenses as well. So just be very cautious. Choose a reputable publisher. Your other pitfall is not just a predatory publisher, but you now have mass vanity publishers. So they also spend their time, but they surf social media. They look at Twitter, Facebook, or Instagram. And if they find that you have a work that you've recently submitted, they then target you. And you, as a young emerging researcher, feel completely flattered that you've been noticed. However, these mass vanity publishers have got no peer reviews or editorial processes that are conducted properly. The next minute, once you start negotiating with them, some of them by the second email are asking for your banking details, and now you're under the impression you're going to be generating masses of royalties. Then the next step is they demand exclusive distribution rights. They want complete exclusivity of your work. Then they want ownership of your print and electronic rights as well. And before you've realized, you've assigned it all. So we advise you to be very cautious of your predatory and your mass vanity publishers. We also tell you try and achieve a workable compromise between the publisher and yourself and between Stellenbosch University. We are always there to advise you and assist you, because we get a lot of instances where the agreement has already been signed by the student, the work is about to be published, and then discover the student didn't have the rights to sign the agreement and assign the copyright. And then it also gets us involved in a bit of a legal wrangle. So we advise you, go up front. If you are planning a publication, send us an email, tell us what you're planning, and we can advise you. There is an intellectual property policy of the institution. It's available on our INOFA's website, and I'll share the link with you at the end of the presentation. Access it, see what you may and may not do, and who you must contact and who you can approach for assistance when you are trying to protect your own intellectual property. And then we are a public research institution. So our core business is creating content. So we are not going to grant exclusive rights to a publisher, because we want wide dissemination of all your research, not just through your publications and our publications, but also through our repositories as well, and through certain open access platforms. By granting exclusive rights, you are restricting actually your own research. Now, there is a Spark addendum that you can negotiate with the publisher where you do assign rights to the publisher as an institution, but we ask that the researcher maintain the right to use that content for further research within the institution. In other words, if the researcher is a lecturer, that they're still able to use that content for lecturing purposes. So there is a way that you can negotiate that you don't assign everything, so that you're actually restricted or inhibited on any research that you'll be doing further. So now just a word of caution. It's what we are calling a copyright watch. Between 2018 and right up until this current moment, we were alerted to external commercial open electronic platforms where Stellenbosch University course content, lecture slides, tests, examination papers, student assignments, theses, essays, and SU course notes were uploaded onto these external electronic platforms. Now, unfortunately, I'm not allowed to tell you what the names of the platform are on a public forum. But what is happening is they're distributing any SU content, academic content, content that students created, via these websites for their financial gain, most certainly not for the university's financial gain. And they're doing it under the name of the institution and the trademark of the institution. So we're not sitting just with copyright infringement in these instances, we're sitting with trademark infringement as well. Now, the problem here is that in some instances, these are students themselves that have graduated and are now alumni of the institution that are uploading their old course notes and their assignments and their thesis onto these platforms and earning money off that. We have been issuing regular letters of demands and takedown notices to these website owners. There's 6 platforms that we currently watch and monitor. The scale of infringement is huge. There are more than 6,000, we're almost at 6,500 now, items of SU academic material in total. We are literally every week asking certain websites to take down certain content. The impact that this has over and above that the financial gain of our trademark and our copyright is that a lot of the content has been uploaded, and it's students that graduated in 2012, 2014. It's outdated academic content, and especially in a scientific, medical, mathematical, engineering field, it's creating the impression that we are actually still using outdated academic content. So now our brand management is being associated with what we refer to as subpar academic content. So we are appealing to you to not just take anything that you create while you are studying at the institution or in the course and scope of your employment at the institution and put it on external electronic platforms to generate financial and commercial gain for yourself. Some of the students even go so far as on the website to indicate that they managed to pay for their move from Cape Town to Joburg by selling their content. It's not their content, it's Stellenbosch University's content. So that's just to make you alert and aware of it from that perspective. And that brings me to the end of this copyright presentation. I have included in the presentation, I'm sure it's going to be distributed or available for distribution, various links that you can go and visit Stellenbosch University's Intellectual Property Policy, the yearbook publication, copies of the Copyright Act. But just please bear in mind that it's very difficult to implement the Copyright Act in our current pandemic conditions as well. And that brings me to the end of this presentation. Thank you.
Well, thank you very much, Carol. Are there any questions to Mrs. Scott? Oh, I see there's a hand raised. You're welcome to unmute yourself, Ms. Similane.
Yes, good morning. How are you?
Good morning.
Morning. Thank you very much for the opportunity. I realize that as you're going through the content, there are a bit of like gray lines where one cannot be sure as to whether we're infringing the copyright rules or not. But just as a question, you know, it happens sometimes that you're in a process of doing some research, particularly when you are still on the problem formulation stage, and you are looking at how to approach a particular problem, and you come across, say for example, a paper. So I'm typically an engineering student. But I come across a paper that is using a certain method in stock exchange. And I want to implement that method because I believe, or the way in which the method has been applied in stock exchange, it can somehow be applied in an engineering space. And I take a significant portion of the method that is applied on that stock exchange and actually use it in the engineering space, probably with a few changes here and there. But I can say that confidently, that the backbone of that concept would have been taken from a few papers that you came across that are not necessarily engineering papers, but from other disciplines, simply because that method has not been used in the engineering space. Well, can that in any way be considered to be copyright infringement, if I can call it that, when I'm doing against the copyright rules and regulations?
Look, you're using a methodology that was originally created by someone else, correct?
That is correct, yes.
And you are applying it to the methodology that you are wanting to use. So you've got an original source that you are using and that you are going to be applying. You would need to request permission. Are you able to determine who created the original methodology?
I am able to devise that. That is correct.
Yes, so the correct process would be to request that permission, because it's not going to be, let's say there's a 5 or 10% chance that they could refuse permission. The chances are pretty good they would grant you permission, especially the way you've described how you are going to be implementing and applying it. If you indicate that when you're requesting permission, the chances are pretty good they're going to give you permission, but then you know you are free to use and apply it in the way you want to use and apply it. By not going down that road, it's always going to concern you. The fact that you've asked the question means that it's raised a point in your mind, should I be requesting permission for this or not? And I would advise you, I would request permission. If I'm able to find out where the original methodology came from and I indicate to somebody I want to use and apply it in a different format or in a different way, I would request permission to do so.
Okay. So it does suffice as long as one has spoken to the owner. Not the original author.
No, not spoken. You must just ask him. You just want to confirm your conversation that you hereby grant permission. Just get it in writing that you are free to use it and apply it whichever way you want.
Okay.
Okay, don't let it be a verbal permission. Let him just grant you that permission to use it.
All right.
Okay.
Yeah. Yes.
Are there any more questions?
Yes, I see here in the chat there is a question from Ms. Nalubega.
All right, Ms. Nalubega, where does the machine learning-based approach come from? Where was the original source of the machine learning-based approach that you're using in forecasting the traffic?
It
You're
comes
welcome.
from, okay, hello, it comes from the literature that I've been studying. People have written books on different machine learning models. So I would want to get a particular one to use for forecasting my traffic.
All right.
Do I need
so it's in a book. It was in a publication.
Yes, publication.
And you're going to use it verbatim, slavically, as it is, as it appears in that publication. You're going to be using that as well, exactly in that
No,
format.
I'm not in that format because I have different parameters that I have to incorporate in that approach, in that method.
Mm-hmm.
But still, it's under the same machine learning approach. Yeah.
I would say err on the side of caution, request permission to use it. And if you're going to be using it with other content and modifying it, request permission to adapt it slightly.
Okay, thank you so much.
All right.
All right. Are there any other questions for Mrs. Scott, or can we conclude the session?
It looks, Kirshner, as if we are done. I just want to
Yes.
say, though, that if anybody has got anything that they don't want to raise right now in this forum because they do believe they could have been utilizing it incorrectly, or because they just don't want to raise it in the forum, they're welcome to contact us, and we will advise them accordingly. They can email me. It's not a problem.
All right, great. Marlene, can I hand over to you?
I would just like to say thank you, Carol, for your knowledge and your willingness to share it with us. And I'm sure the students can contact you again to if they need anything else. Is there anything else from your side that you want to mention or say?
Absolutely not. And I just want to say that in the words of, can't remember if it was Oscar Wilde or Mark Twain that said, where copyright issues arise, the fools conglomerate. So that is basically what happens in the copyright environment.
Yeah.
It's always grey. There's never anything that's clear cut. So, and everything is literally a case-by-case scenario in a copyright environment.
That's why you are so important, and please don't resign or go on pension. Just stay here while I am here, because I have contacted you so many times and you were always willing and knowledgeable. So thank you, a big thank you from you. And with this we conclude the session.
Thank you very much.
Thank you, Carol. Okay, bye to everyone.
Goodbye, everybody.
Bye-bye.